The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. Thank you so much for joining us today for our free webinar, Protect Your Assets from a Nursing Home. It looks like we have a big group today, which is really awesome. We're so happy that we're able to do this every month for our clients and for the general public to keep you informed on some of what we believe are the most important topics, and they're also topics we get asked about a lot, so we're happy that you could join us today. For those of you joining us for the first time, my name is Amanda, and I am the Client Service Associate for Stonehearth. I've been with SCM for 3 years, and my primary role includes client service, marketing, and compliance. I would like to just start off with a few housekeeping items. On your GoToMeeting taskbar, you should see a section titled Questions. Please feel free to submit your questions throughout the course of the webinar. I will be monitoring all the questions and will ask Jamie to answer as many as time allows at the end. And if we run low on time and are unable to get to your question, Jamie or myself will reach out to you directly to make sure we get your question answered. Now I would like to introduce our speaker for today. Jamie Upson is Stonehearth's President and CEO. Jamie has been with Stonehearth since 2000, and in the first couple of years here, he focused mostly on portfolio management, design, strategy, and product analysis. In 2006, Jamie passed the CFP exam, and he spent the next 11 years here at SEM co-managing client portfolios and building, analyzing, and monitoring client financial plans. And in 2017, Jamie purchased the firm and hopes to lead the firm forward and continue to help our clients meet their financial goals. Jamie, thank you so much for joining us today.
Thank you very much, Amanda, and thank you everyone for joining us. As Amanda said, this continues to be a pretty popular subject, so we're pretty excited to be offering this one. This is our second time discussing ways and strategies to protect your assets from a nursing home. I think in many respects, this is important not only for ourselves, but it might also be important for our parents. We're getting to the stage where this is a multi-generational planning that's taking place. And it's important to be having these conversations with your family. So this is really driven towards putting together a presentation and a white paper so that you can quickly identify what stage you're in to identify those strategies that may or may not be applicable. But it's really designed to start the conversation with your family. I'm not an attorney. I'm not pretending to be an attorney. You need a qualified elder care law office or attorney to help you implement these strategies and to validate that it's going to work as best they can in a dynamic landscape that keeps changing each year. One of my goals with this one was to look at some of the changes that have taken place in 2018, which I've obviously updated, and so this will be all the numbers reflecting the changes that have happened over the last 12 months. So let's dive right in. First, just a shameless plug, Stonehearth Capital Management. We are an independent fiduciary financial advisory firm, helping families with their finances for over 35 years, thanks to Richard Prout, who founded this firm. As Amanda said, I've been here for the past 18 years. Predominantly, we help manage risks for the families that we support and identify opportunities. Nursing home protection would clearly fall in the category of managing risks. First, what are the three primary sources that people have available to pay for the care of somebody if they're in a nursing home, whether it's themselves or if it's their spouse or their loved ones? Privately using your own assets and income, that's the primary source that's available. It's also the one that gives you the most options of when and how you're going to receive care. There's also, for those people that purchase long-term care insurance, I haven't seen any of the recent stats, but across our client base, it's probably about maybe 15% of our client base purchase long-term care. It has gotten more expensive. The industry has changed over the years. There's fewer players, fewer insurance companies that are staying in this. It's a really hard challenge because they're pricing products today, insurance policies, for expectations of what the costs are going to look like 20 to 30 years down the road when you're going to be more likely to put in a claim. And then finally, for those people that have less in assets or fewer assets, there's the Medicaid system and what we call Mass Health in Massachusetts. And that is available as a backdrop or a backstop to make sure that people are taken care of and that their needs are met when there's skilled nursing facility need that someone's facing. We're going to start, those people that regularly join us here. I like to do polls. I like to try to keep it as interactive, even though you have to type in your questions. We can't have it open mic for obvious reasons. But one of the things that I want to show you here is the question is, who runs Medicaid? Is it the federal government? Is it the state government? Or is it jointly run by the federal and state government? Go ahead and punch in what you think the answer is. We're getting some, we got good participation here, I can see already. And in about 5 more seconds, I'll shut the poll down and I'll show you the results. So most of you elected 75% federal and state government, and you're correct. That's actually very important, because what I'm going to refer to today is really just the rules in Massachusetts. While there are some overlaps between other states and Massachusetts, there are definitely some differences. So this is a very state-specific area that the strategies that are utilized, you need to really consult with a local attorney. So if my parents live in Florida and they're dealing with nursing home care in Florida, I can't consult with a Massachusetts attorney. I really should go consult with a Florida attorney to make sure that where my parents are going to receive the care, that the strategies would work. So the first line item that I have here is it is a joint venture between the federal and the state governments. Mass Health is available to families with limited resources. You have to meet certain eligibility requirements, and as I just said, the rules vary between states. We're going to spend a lot of time on eligibility requirements, because in order to get onto Medicaid, you have to meet certain criteria, which are predominantly in the income and the asset space. This is the first of 2 disclosures. And I just want to make sure that I drive this point home. These are the most popular strategies, but they're not all of the available strategies that exist. Some strategies are not effective in certain states. I'm focusing on Massachusetts today because that's where we reside, and most of our clients reside. Important to work with a qualified elder law attorney. No recommendations today. I'm just sharing my research with you. And income tax and estate planning goals need to be considered. That is a very important one. Sometimes an elder law attorney might suggest that you do this, but yet what they're not looking or giving as much attention to are maybe the income tax ramifications. Whereas if you were talking to a CPA, they're going to tend to focus more on the income tax ramifications and maybe some of the other impacts. So it's important to really get a team together. I like to participate in these for our clients, where we hold conference calls, or we actually go out and meet with the attorney, the elder law attorney, to try to incorporate a plan for the family that we're supporting. Medicaid eligibility requirements. There's the income, there's the assets, and then I'm going to also talk about some excluded assets, and another area that may be new for many of you is called estate recovery. So first, income rules, they vary between states. The general rule of thumb is that if you have less income than what the nursing home expenses are, then you're most likely going to qualify. It doesn't mean you're going to get benefits, but at least you should meet the income criteria. And the second component is the asset criteria. This is the one that has and maintains most of the available strategies. This is where you'll want to explore some of the different strategies that are available to see if there's ways that you can try to shelter or protect certain assets. The Medicaid applicant, this is the person, you'll see this throughout the presentation and the white paper if you read that one. The Medicaid applicant is the person that's going into the nursing home. The healthy spouse is the spouse, if there is a spouse, that's the one that's staying at home, who does not need nursing home care. So the Medicaid applicant, they're only allowed to have $2,000 or less. If you have more than $2,000 in the Medicaid applicant's name, they do not meet the asset eligibility requirements. The healthy spouse, this is an increased number. This one did change from last year. It's up to 123,600. There are some quirky calculations, mass included, so this is just, I use this as a broad number. It is the number that you see, but they do have some quirky calculations that go on behind the scenes. Some of the things that you don't need to include, the primary residence, the home you live in. Usually that's excluded, not always, but usually it is. You can have one automobile. You can and should prepay funeral expenses, can keep your personal belongings, and a small amount of life insurance. I think the life insurance is about $1,500 of cash value that you're allowed to keep in that. Estate recovery, this is something that often people don't spend as much time focusing on. Medicaid wants to recover their payments that they make. Now, there's two ways that they recover. First is while somebody's actually in the nursing home, one of the things that they'll many times do, especially if there's just one spouse or widow, we're not dealing with a married couple, is if they have their house and the Medicaid applicant goes into the nursing home, qualifies for Medicaid, and Mass Health or Medicaid start paying for their care. The state will likely put a lien on your house so that if you end up selling your house while you're living, they want to be recouped for their expense. That's something that's a growing trend, not only in Massachusetts, but across the country. The other thing to remember is that many states, Massachusetts included, they only go after the assets that go through the probate process. So if an asset is probated, then the state, then the Medicaid or Mass Health in Massachusetts wants to recoup their expense. And that is the second way that they will recover some of their expenses after somebody's passed away. And if, for example, their house passes through the probate process, then that's how the state finds out or Mass Health finds out what assets you have, and then they want to be recouped for that expense that they've paid since they started covering you in the nursing home facility. So now we're going to switch over to strategies, and I really broke these out I tried to highlight the area that we're focusing on. So in this particular section, we're going to focus on income requirements, and then two subcategories of single or widowers, widowers, and then you've got married couples. So when we're focusing on meeting the income requirements to qualify, this is what we're trying to do, is to qualify for Mass Health or Medicaid. A single or a widow, there's not much that you can do. But for married couples, one of the things that you want to remember, this is a key ingredient here when you're doing Medicaid planning, is that the healthy spouse is allowed to keep their income. So if there's joint income coming in, let's say that you have a rental property, one of the things that you may want to do is start to shift that income over to the healthy spouse. There are other things that we'll talk about later having to deal with annuities, where you can actually purchase an annuity and that will shift assets and income over into the healthy spouse's name. And the healthy spouse is allowed to keep whatever income's coming in. They are not required to use that income to pay for the Medicaid applicant's care. So that's, again, a very crucial and important component that needs to be understood when you're looking at some of these strategies. The other thing to remember is Mass Health and Medicaid have a minimum spousal needs amount. What that means is that the healthy spouse is allowed to keep at least $2,030 of the family's income. So if the unhealthy spouse was the only person that received income, and they earned $3,000 a month through a pension, then the healthy spouse would at least be able to keep the first $2,030 of it, and they would not be required to use that money for nursing home expenses. If the healthy spouse needs more than $2,030, then one of the things that could and should be done is to schedule a hearing with Medicaid to see if you can get them to increase that amount. For example, what if your mortgage is $2,500 a month? Then you can petition Mass Health and explain your situation to see if they will increase that. Each of the agents that work for Mass Health do have some discretion there. We're going to shift gears and now talk about how do you meet the asset requirements. Again, these are strategies. I want to first reference transfers and gifts, because this is an important piece to remember. If I'm going into a nursing home and I need to keep my assets below $2,000 or in the $120,000 range if I'm married, then why not just give away everything above that? Well, the reason is because there's a 5-year look back. I think many people are familiar with that word, that concept, and here is where it applies. You can't just give away your money. If you do give your money away within the last 5 years and you apply for Mass Health, then what they're going to do is ask you if you've made any gifts in the last 5 years, and if you check the box yes, then they're going to apply a penalty period, which is also known as a disqualifying transfer. It's a formula that they use. They take the amount of the gift and they look at the average nursing home expense in your state, and they divide those and they determine the number of months that you're ineligible for Mass Health, where you have to pay for your own care. It's basically a way for them to just say, hey, we know you gave that money away and we're not going to pay for your care. Get that money back and you pay for your own care during this disqualifying period. One thing to remember when we're talking about transfers and gifts, I am not referring to transfers and gifts between spouses. Those are fine. You're allowed to do that. That does not trigger any warning signs when we're looking at the 5-year look back. Again, transfers and gifts between spouses. I can give my spouse my share of our checking account, and that does not need to be disclosed when we're talking about the 5-year look back when I'm applying for Mass Health. So let's focus on singles and widows. First, something to remember, I said that most of the time primary residences are excluded, or what they call non-countable assets. For singles and widows, that amount. Yep.
Sorry to interrupt you. Some people are still seeing the poll page. Are you able to try and refresh that for us?
I think that went away. Hopefully that, if somebody, I'll keep going, and if somebody could just
Sure.
jot in a question there to just let you know, and just let me know if that's still the problem.
Thank you.
Yep. Strategies to meet asset requirements, and just so everybody knows, this is recorded, and I did do a white paper, so if you missed those last couple pieces, that's fine. I apologize about that, but it is going to be recorded, so you can always go back to that section. So for singles and widows, their primary residence in Massachusetts, you can exclude the first $858,000. If you have more than that, then they're going to start including the excess. If you, just something to remember, and I already referenced this, if you're a single person and you go into a nursing home, it is likely that Medicaid is going to put a lien on your property, so that if you sell the property, then they want to be paid back for whatever expenses they've already incurred. Careful consideration needs to be, or you need to give careful consideration to scenarios where you sell your house, because we just said that primary residences are a non-countable asset. And if you sell the property, you just turned a non-countable asset into cash, which cash is countable. So in most instances, you do not want to sell your house. One of the things that most attorneys suggest is that if you're single and you go into a nursing home, the thing that you want to do is file something with Mass Health telling them that you intend to return home. Now, that might not work forever, because as time keeps clicking on, ticking on, they might actually come back to you and say, look, you did this 3 months ago. We just asked you this again. You're still not going home. Eventually, they might just put the lien on. And it is also possible that they could force a sale if they don't think that you're going to be going home. Again, their goal is to be recouped. Their goal is to recover their expenses. Other assets, one of the things that you can do is spend down those assets before you fill out the Mass Health application. Some of the ways that you do that is you can buy a new car, you can prepay funeral expenses, you can do home renovations, go ahead and buy that 60-inch flat screen TV that you've always wanted, pay off some debt. And then if you're in crisis mode, which is, hey, we didn't see this coming, I had a stroke, I'm going into the nursing home, one of the other things that you can do is purchase an immediate annuity or put some money into what they call a pooled trust. There are a couple of popular pooled trusts in Massachusetts that people utilize to shelter assets, to get assets down to the point that they become eligible so that their assets are below $2,000 and they can now apply for Medicaid. We're going to next focus on, again, assets, but for married couples. First, remember, primary residences in this scenario, they're non-countable. Their goal, Mass Health's or Medicaid's goal is not to kick the healthy spouse to the curb. They want to maintain, they're happy to allow the healthy spouse to maintain the property. Other assets, again, for the person that's in the nursing home, they can only have up to $2,000, and the healthy spouse can have $123,600. So again, if you're above that, how do you start reducing your asset level so that it falls within those two numbers? Well, you can do the spend down strategy, which is very similar to the single person. Buy a new car, prepay funeral expenses, go ahead and do some home renovations, 60-inch TV, and pay off some debt. If you were planning ahead and you were comfortable planning ahead, as long as you do it 5 years and a day ahead, you can go ahead and start making some gifts or transfers to non-spouses or irrevocable trusts. Again, we've got the 5-year look back, so this only works if you do this 5 years before you get sick. Another area for crisis planning, which again is last minute planning, the healthy spouse can purchase an annuity. I think this has been a popular strategy for, I don't know, since I've been doing this, since I've been researching these things. So at least for the last 18 years, we've helped purchase a couple of these for families. Again, it needs to be done in unison with an elder care law attorney because certain calculations must be done. But this is still an effective strategy to purchase an annuity for the healthy spouse. I have an example at the end that I'll go through to show you. Schedule a hearing with the Medicaid, Again, similar to the income requirements, if the healthy spouse needs more money or more assets in this scenario, then you can schedule a meeting with Medicaid to plead your case as to why you need to maintain more than $123,600 in assets. Something to also remember, if your loved one or your spouse goes into a nursing home, the healthy spouse should update their beneficiaries on their accounts, their life insurance, and also their will. Typically, that means naming the children as the new beneficiary and disinheriting your spouse, the unhealthy spouse who's receiving care. If you really want your unhealthy spouse, the one that's in the nursing home, to be the beneficiary, then there are other things called testamentary trusts that you can set up within your will. That is also an effective strategy. And actually, I mentioned the testamentary trust right there. We're going to do poll number 2. Hopefully, I don't screw this one up. Launch poll. What kind of annuity would a healthy spouse purchase? An equity indexed annuity, a single premium immediate annuity, variable annuity, or a fixed annuity? These are the most common types of annuities out there, and you need to purchase a particular type if you want it to be effective at qualifying for Medicaid benefits. If you don't know, go ahead and take a guess. Okay, good. I'm going to close this down. I'll share results. So the majority picked 50% selected fixed. The actual answer is a single premium immediate annuity. Single premium means you give them a block of assets. So if I have $200,000 sitting in a bank account and I want to turn that into like a pension or an income stream, then I give an insurance company my $200,000, and based on my age and some other things that I elect, they will tell me and give me a quote based on that $200,000 and the other variables, how much money they're willing to pay me on a monthly basis going forward. That is what they call a single premium immediate, meaning we're turning the income stream on immediately. So single premium immediate annuity. All right, and the third area that I promised to talk about is estate recovery, and these are strategies to try to protect. This is really after somebody, the person that was receiving care, after they pass away, we want to try, if possible, to shelter some of the assets so that Medicaid doesn't try to go after the estate or assets that are in the estate to recoup their expenses of what they paid for the Medicaid recipient. So for singles or widowers, the primary residence, one of the key ingredients that I mentioned earlier is that if an asset, like your home, does not go through probate, which means we have to read your will to identify who you want to get the asset, then the state right now, Medicaid does not go after your home to recoup their expenses, which they call estate recovery. So again, if I'm single and I go into a nursing home, I don't want to just leave my property as is without naming a beneficiary, because if I do, if I pass away and my heirs have to read my will to determine who's going to get the house, then Medicaid stands a chance of recouping when that house is sold to pay off my heirs. They stand a chance of being paid back anything that they covered for me while I was in the nursing home. Some other exemptions or some other ways to protect the house from Medicaid going after your home after you pass away: have a child live and care for you for 2 years before you go into a nursing home, then transfer the home to the child. There is no penalty. This is not a disqualifying transfer. The whole idea here is the state and the government is rewarding your child for keeping you out of the nursing home that would incur large expenses. Another thing you can do, if again, if you're single and you know that the state is going to recover their expenses, then one of the things that you could do is just try to rent the property, try to generate some income so that the state does not recoup as much. If you're able to generate $1,000 a month by renting that vacant property, then that's $1,000 a month that the state is not paying for you to contributing to keep you in the nursing home. And that means when they look to recoup their expenses after you pass away, that just means there's less that they need to recoup. Another exemption is for those that do purchase long-term care insurance. As long as you ensure that the daily benefit is $125 a day and it has 2 years of benefits, then that exempts that primary residence from being subject to estate recovery. If you plan in advance, as a financial planner, I'm a big fan of these. If you know that you're in your forever home, one of the things that you may want to consider doing with your primary residence is to gift it to your kids while retaining a life estate. The other thing that you could do is gift it to an irrevocable trust. Those are both things that would accomplish the goal. You got to do this 5 years in advance because you're still making a gift to somebody or something. But as long as you can get through 5 years and a day when you apply for Medicaid benefits, you won't have to disclose that gift or transfer. And then they also will not go after that asset because through the estate recovery, because you don't own it any longer. If you have other assets, again, there's not that much that you can do. the state's going to want to recover. You technically shouldn't have that much in assets if you were already collecting Medicaid benefits. One of the things that I just wanted to highlight, I actually was prepping for this again this morning, and one of the things that I happened to find was a recent article. It actually came to my email this morning, and I just want to show you that Medicaid is testing the boundaries of irrevocable trusts. I've read about it, I've heard about it. So far, irrevocable trusts, if they're structured properly with either your home or your assets, then Mass Health or Medicaid has left them alone. However, lately, Mass Health and Medicaid have been kind of poking holes at these trusts, trying to say that something that is considered non-countable is countable and needs to be spent down before they're willing to pay for your care. So it was not that long ago, this lady, Susan Yanow, the courts actually ruled that she had set up a trust, and they said that the way that it was structured, it didn't have the necessary provisions in place that would allow it to be a non-countable asset. They actually considered it a countable asset because they felt like she had access to the principal in the irrevocable trust. And what happened was, and I just want to show you at the end here, just how fresh and recent this is. So this was earlier this month, March 7th, 2018. An appeals court came back in and said that Mass Health, keep your hands off of that trust. So they actually said the effect of the provisions of self-settled irrevocable trusts on eligibility for Medicaid benefits has been the subject of considerable discussions. Nonetheless, it is settled that properly structured such trusts may be used to place assets beyond the settler's reach and without adverse effect on the settler's Medicaid eligibility. Generally speaking, assets must be made unavailable to the settler in order to avoid being treated as a countable asset for purposes of Medicaid eligibility. So, you know, the courts ruled that the trust was not set up properly, and it took the appeals process for them to back that out and to say, no, that trust actually was done properly. That just makes me a little nervous. Just make sure that you're working with qualified attorneys. And even those qualified attorneys, you know, they're doing their best, but, you know, that doesn't mean that they're not going to be tested in the courts. Finally, I want to go over estate recovery for married individuals. You get your primary residence. Consider transferring 100% of the ownership of the property to the healthy spouse and update your wills. Again, you just don't want it to be something that goes through the unhealthy spouse's estate. Other assets, consider transferring 100% ownership of those assets to the healthy spouse as well. Careful with retirement accounts. So if I have a $500,000 IRA account and I want to move that over to my healthy spouse, I can't just change the title of that to my spouse. I have to liquidate the IRA account and then move the money over to my spouse. In the liquidation process of an IRA, it loses its IRA structure, and that triggers an income tax. Now, I'm making it sound like that's horrible, and obviously taxes are not great, but one of the things to consider is if somebody's going into a nursing home, they probably have high medical expenses, and at least with the recent tax reform, they've maintained medical expenses as something that we can write off. So while you'll trigger an income tax by closing out an IRA, you should have some deductible medical expenses. Obviously, they have to exceed a certain threshold before they're deductible, but that will help to offset some of the taxes. Maybe not all, it all depends on the situation. I'm going to go through two case studies just to give you some examples. So here we have Sheila Robinson. She's a widow, she's 80 years of age, she has 2 kids, she lives in Massachusetts, and she's relatively healthy. She has income of Social Security and pension, so she totals $2,700 of income. She has for assets her forever home, and I always use that when I'm talking to the families that we support, is I say, if you know that you're in your forever home, then we want to consider some other strategies to try to lock up that property and make it inaccessible or increase the chances that it's inaccessible to estate recovery through Medicaid. So her forever home is valued at $500,000. She's got $250 in the bank, and she drives a Toyota Avalon that's got a Kelley Blue Book of $25,000. When she's 80, so this is currently, we're gonna project that she moves forward 5 years in a second, but currently she says, you know what, I'm gonna gift my residence to my 2 kids to avoid estate recovery. The government has these tables that you have to go through, so you can't